Hi, Dave Bliven, Bronx and Westchester divorce attorney for another episode of Lessons from the Divorce Wars. So this lesson comes from a client that I'm quite sympathetic to. I think at the end of the day, she got really screwed in her case, but there's an important lesson in her case as well, which is you have to be cognizant that the other side may just be determined to wear you down. And you have to be realistic with how much money you have to spend on your divorce attorney in making the cost-benefit analysis as to how much are your claims worth versus how much is it going to cost for me to take the issue to trial. In other words, you don't want to spend $30,000, $40,000, $50,000 to go to trial when you win on principle, but your claims are only worth $30,000, $40,000, or $50,000. Even if they're worth slightly more than that, you have to know that if you take a case to trial, you could lose. Or the judge could give you less than what you think, and even your lawyer thinks your claims are worth. They could give credits to the other side that you're maybe not anticipating that they're going to give. So this client, she made probably about $100,000 a year. Husband made, probably about 130, 140, 150, somewhere in that range, which is somewhat on the average side for Westchester County. But there were a number of claims that both myself and she felt she was on the right side of both the facts and the law. So, as but one example, the husband won a bunch of money through gambling. There was no doubt about that. He had the deposits into his bank account, so it was seemingly an easy issue to prove at trial. Another thing is he bought a car for his father during the time of the marriage before the divorce was filed, but essentially said, oh, well, that car is my father's. That car is not mine. So I'm not agreeing to treat that car as marital property, even though there was no dispute that he took the money out of his marital bank account because, again, during the time of a marriage, your names on accounts do not matter as a general rule. Any money put into a bank account is presumptively marital property. So if he takes money out of a bank account, spends it on a car, but puts the car into somebody else's name, it's still marital property. Because you basically took marital money and invested it in someone else's asset. The general rule is that can be recouped to the marital estate. So this guy did that. There was little doubt about it, but he, through his divorce attorney, remained steadfast. I'm not going to share a single penny of that money with my wife. I'm just not going to do it. So we went all the way through a contested divorce case, got all the documentation, did depositions, and depositions are quite costly. They cost on average about $5,000 to do. So she spent a boatload of money to get up to the point of trial. We actually had trial dates in front of the divorce judge set. But then I had to have a frank discussion with her and said, look, problem is in Westchester County, you have to do trial notebooks, you have to do research, you have to prepare your client for trial, you have to budget the fact that even if it's a financial trial, conservatively, you're looking at about 3 days of trial. And the reason for that is a lot of the judges are very busy, whether you're talking Westchester or New York City, and they oftentimes put other cases on the day that you're technically scheduled for trial. And so usually the plaintiff side will take one day, the defendant's side will take one day, and then the judge budgets another day for rebuttal evidence, summations, things of that nature. And if you're talking 3 full days of trial at, a typical hourly rate, $500, $600, $700 an hour, and I always tell my clients, budget approximately 2 out-of-court hours for every hour you spend in court. So doing the math, that's roughly 60 some odd hours, again, at that hourly rate, $500, $600, $700 an hour. One can do the math on that. Conservatively, that's $30,000 to do a trial. And the money that she had at stake, where her last offer of settlement was at and his last offer of settlement was somewhere in the range of $30,000, $40,000, $50,000. And so I told her, look, the problem with your case is you are right. I'm on your side. You are correct on the facts and the law. But to take the case to trial, you are going to spend on attorney's fees what your claims are worth. And he's just not willing to settle. So you have to decide for yourself whether it's worth it for you to give me your claim to take the case to trial. In effect, that she would, in all likelihood, go to trial, she'd win, and then she'd get that money from him and turn it right back over to me. And so it was a very difficult decision on my client's part to come to the realization that if the other side is just steadfast and does not want to settle at all, she might just have to give up claims that she is right on. And so you really have to take that into consideration, that at the end of the day, the judge cannot force the other side to settle. The judge can highly recommend settlement. The judge could even say, look, if I decide one side is being really unfair, maybe there could be an award of counsel fees. But in this case, there wasn't enough of a disparity of income that would really warrant that. And so it's just a lesson to take into consideration that even when you're right on the facts and even when you're right on the law, it still may not be worth it from a pure cost-benefit analysis to take the case to trial. And you just really want to sit down with your attorney, especially before you go down the road of a contested divorce case, and just see if there's any way possible that you can settle those claims, especially when the parties are not off by that much, prior to spending all that money in the first place. So this is another lesson from the Divorce Wars. For more answers like this, definitely check out my blog. You can find it at blivenlaw.net/blog. And I'll see you next time. Thanks.